All right, we are just about to get started, and I'm glad to have you with me. We're going to see if we can get a little picture going here in just a minute. Well, we're getting there. Okay, today we're going to be talking about being a landlord during this recovery. And I say recovery because I hope you agree with me that the economy is hitting on all cylinders. I mean, we are smoking, boys and girls. And that creates an opportunity for you and for me. And that's what I want to talk about today. So, let's see if we can get this video going. Absolutely. Hi, everybody. John Adams here. Glad to see you. In the upper right-hand corner, you can control the size of my picture. And if you want it bigger, you can make it bigger. If you, I would recommend you make it go away entirely because it's just distracting. But nonetheless, happy to have you with us on this very special presentation. The first question you should be asking is, who is John Adams and why should you listen to me? By the way, I will be on Fox 5 this coming Tuesday at 8:30 a.m. for those of you that are interested. The answer is I've been a property manager in Georgia for 40 years, and believe it or not, I've made every conceivable mistake in that time period. I'm an investor. I'm an entrepreneur, which is just a fancy French word for somebody who looks for an opportunity. I've been a licensed Georgia broker since 1977. And I've had no complaints so far, at least with the Georgia Real Estate Commission. Never been arrested. I've never been bankrupt. What a boring life. I did write a book called The Landlord Survival Guide, which has sold very, very well. And for that, I am grateful. And most important of it all, I am an Eagle Scout, and that means I am trustworthy. So watch this. Isn't that great? I cause that to play in my house every morning when I wake up. So now that we've gotten past that part, we can now move on to more substantive issues here. Warren Buffett says, if you don't find a way to make money while you sleep, you will work until you die. And I hope that doesn't happen to you. It's not happening to me. The way that I found to make money while I sleep is to be a landlord. And that's what we're talking about today. But over the last 40 years, it's gotten a lot more complicated than it used to be. By the way, I have appeared on stage with Warren Buffett and shaken his hand. In fact, Margie has combed his hair, among other things. So Warren and I are good friends. But let's talk about the CDC eviction ban that was put in place to prevent the spread of COVID-19. Now, I think we can all pretty much agree that with 130 million Americans who have received at least one dose of the vaccine, and by the way, I've received two, I feel great. I don't know about you. I don't think I've had the virus, but I may have. Who knows? But I just felt like it was not right for the CDC to tell me that I couldn't evict my tenant who was not meeting the responsibility that they had agreed to meet as part of our lease contract. And I began talking to attorneys and other landlords and interested parties about what can be done about this. Well, I wasn't the only one. Guess what? A lot of people are interested in how to beat the CDC ban. So I found this on, I don't know what, some television station, but I want you to watch it. Here we go. Pay close attention.
Pandemic lockdowns led to millions of layoffs. Housing activists took to the streets calling for rent relief as a massive wave of evictions loomed. And the movement to help people keep their homes got a boost when the U.S. Centers for Disease Control and Prevention issued a moratorium on evictions. But as the coronavirus pandemic moves into its second year, Reuters uncovered cases such as Marvia Robinson, where landlords have sought to evict tenants anyway. Robinson, a 63-year-old Greyhound bus driver, was struggling to make ends meet after the coach line cut her hours, and she fell behind on rent on her Orlando home. But an Orange County rent relief program offered landlords $4,000 in back rent, and Robinson emailed the property owner, Invitation Homes, to see if it would take that to cover what she owed. Instead, it suggested she seek help from payday lenders or try selling blood, plasma, hair, and donor eggs. In January, Invitation Homes sued to evict Robinson. 2 days later, Robinson filed a handwritten declaration with the county civil court attesting that she qualified for relief under the U.S. Centers for Disease Control and Prevention's National Moratorium on Evictions. It didn't work. In February, an Orange County judge approved Robinson's eviction, and by March, she was out. A spokesperson for Invitation Homes said it would not comment on individual renters, but said the company had the right to challenge the CDC moratorium when renters made no arrangements to repay rent due. The fight over rent can pit tenants scrambling to make ends meet against mom-and-pop landlords heavily reliant on rental income. But a Reuters review of hundreds of court filings as well as interviews show it's the big, deep-pocketed corporate landlords with portfolios spanning multiple states that have been the most aggressive in filing eviction cases. Robinson now lives out of her car and stays with friends, or when she has the cash, in a hotel.
Okay.
Pandemic lockdowns led to millions of layoffs.
So, as you can see from that news piece, somebody is able to, in many cases, go ahead and evict people who have given their declaration to the landlord saying, I don't have to pay rent anymore. And let's examine some alternatives here. I think you're going to like this. By the way, this is being recorded and I will make it available to you. So with the CDC agency order in place, and by the way, they've just extended it, so it's going to last until sometime in September, end of September, I think. The question is, can I evict a tenant for non-payment of rent? And the answer is yes, unless they jump through hoops. And I mean a lot of hoops. And we're going to see today exactly what those are. First, they have to have exhausted all of the opportunities to get help. Next, they have to expect to earn less than $99,000 in 2021. I don't think that's going to be a real problem. They have to be unable to pay rent due to substantial loss of household income or a job loss. That's pretty nebulous. And they have to have made their best efforts to make any payment whatsoever. And they also have to state that the eviction will cause them either to become homeless or force them into a shared living arrangement like a homeless shelter where they're more likely to give or get COVID. And finally, they have to have filed the mandated declaration form that I don't have and you shouldn't have either. So how do we beat the CDC eviction ban? Well, here's some great news. There's been some recent guidance from CDC, Health and Human Services, and the Department of Justice. I think what happened was a bunch of do-gooders at Health and Human Services said, well, we don't want people to have to pay rent anymore. So we'll just issue a ban on evictions. And somebody said, well, you can't do that under Health and Human Services. And then somebody said, well, the CDC could probably get away with it. So they did. And of course, that's been challenged as unconstitutional. Last time I checked the Constitution, I don't remember anything mentioned about the CDC, but eventually they went ahead and did that. And since then, the Department of Justice, I think, has been hearing from a lot of people that this is untenable. And so finally, DOJ contacted CDC and their bosses at Health and Human Services and said, we better come out with some guidance. And we'll call it frequently asked questions. Okay. And by the way, during this presentation, I'm going to share with you how you can get your own copy of this guidance from CDC, HHS, and DOJ. Now, here's the good news. Once your tenants are served with a dispossessory action or a summons or whatever it is, the likelihood of them following all of the proper procedures and meeting all of the requirements of the court and appearing in the right place at the right time with a compelling defense is extremely low. In fact, it's very unlikely unless you have rented to an attorney. And if you've done that, I can't help you. So what do? You have no downside because you are going to be challenging the truthfulness of their declaration in good faith under guidance of the United States Department of Justice. No one can accuse you of harassing or attacking these people or of not having I suppose they certainly can claim you have no compassion. I don't know whether I do. I mean, I do, but I got a business to run too. So finally, the thing that's so important here is that eviction judges love the idea of in-court mediation. They want to work it out without having to evict the person. And this creates an opportunity for you to move beyond the eviction and get a judgment for the money and then eventually get possession of your property back, which is exactly what you and I want. Now, maybe they'll do what they say they'll do, but they haven't so far, have they? So let's see how this works. For starters, you don't have to evict to get a non-paying COVID claiming tenant out. You can just wait until their lease expires and you are under no obligation to renew their lease. And you can kick them out and lease to somebody else who has a full-time job and is more likely to keep that job. Okay. 2, you can put them then, if you want to, if they want to stay and they are willing to catch up what they owe you and you want to rent to them, you could put them on a written month-to-month lease with 30 days notice so that every month, if they don't pay, you can kick them out and say you're just not renewing the lease for another 30 days. You have the right to do that. That's when the lease expires. But this has been going on for a while now. So your leases, you need to be aware when they're going to expire. You could renew the lease, but this time with a very high security deposit. So, for example, if the rent was $1,000 a month and they wanted to stay, you could say, well, I'll be happy to let you stay, but I need a $12,000 security deposit, and we'll lower that by $1,000 every month by converting $1,000 of the security deposit into your rent. Well, if they don't want to do that, then they don't have to live there. Or if their lease is not up and you still want to get them out, or at least to catch their attention, you can go ahead with the normal dispossessory action. File your demand notice, file your dispossessory warrant paperwork, and then hire a process server. Now, we're going to walk through this because I want you to understand how this works. But the first thing you need to know is that the magistrate courts are open. Now, they were closed for 7 or 8 months in many counties because the counties didn't know what to do. And they said, well, this is non-essential because it's not life and death, and we just don't really care about landlords anyway. Well, now they've been told, look, you've got to do your job one way or another. And so magistrates courts are, in fact, open in almost every setting. By the way, if you're in one of these awful counties, or you own property in one of these awful counties like Fulton County, where the judicial system reflects the super liberal orientation of many of the residents, God help you. I don't know what you can do. You better talk to your attorney about it. But if the judge is not on your side, it's going to be hard to get anybody to enforce the law. But in most cases, magistrates courts are open. They are accepting dispossessory warrants for reasons other than non-payment. So when you file your dispossessory warrant, when you make your demand, it should not be because they haven't paid the rent. It should be because they do not qualify. You are going to be challenging the veracity of their declaration. And you can then go ahead and say, not only that, they're not paying the rent, but the primary reason that you're filing is that you are challenging the truthfulness of their declaration. And if the court rules that they are not being truthful, then they obviously don't qualify for protection, in which case you can go ahead and get what you want, which is the rent and the property. So state the amount that's owed and ask for possession and a judgment for past due rent, fees, and costs. But make sure that you state that the primary reason is that you wish to challenge the truthfulness of their CDC declaration. And you state the reason as tenant having made a false declaration. Folks, this works, okay? So now, and this is straight from the Department of Justice. I didn't just make this stuff up, and I'm going to show you. By the way, you may run into a low-level clerk when you go to file this at the clerk's office. Those people, one, they are not attorneys. Two, they don't know what they're doing, or they wouldn't be working as assistant clerks at some county accepting dispossessory warrants. And three, they're easily intimidated. So if they say, well, we can't accept this because we're not accepting dispossessories based on non-payment of rent, say that's not what my allegation is here. The reason is that my tenant has made a false declaration, and under this guidance from the Department of Justice, and you can hand them a copy for them to keep, it says here I have a right to challenge this in an appropriate state or municipal court. And I understand that the magistrate's court has jurisdiction here. And they're gonna go to their boss, and their boss is going to say, wow, this guy knows what he's talking about. Okay. So this will work for you, unless like you're in Fulton County or something. So can a tenant still be evicted for reasons other than not paying the full rent? Well, the answer is yes. And so I want you, in addition to everything else, try to find a legitimate reason for evicting. It's not legitimate, another reason for filing the eviction. So, and this guidance I'm reading you now is straight from the DOJ. Yes, you may still be evicted for reasons other than not paying full rent or making a full housing payments. The order does not prevent you from being evicted for, you ready? 1, engaging in criminal activity. Okay, so are your tenants in there smoking dope? Are they selling drugs? What are they doing? Threatening the health or safety of other residents. Are they smoking when they shouldn't be smoking? Is this a no smoking environment? Are they not taking the trash out often enough? Is their place a mess? Number 3, damaging or posing an immediate or significant risk of damage to the property. That covers a lot of ground. Okay, number 4, violating any applicable building code, health ordinance, or similar regulation relating to health and safety. Remember, we're just trying to get them into court here. Okay, so it can be a stretch. Or for violating any other contractual obligation of a tenant's lease other than the timely payment of rent or similar housing related payment, including but not limited, including non-payment or late payment of any fees, penalties, or interest. So if they're violating any contractual obligation, a good example would be if they're not allowed to park in the yard and they're parking in the yard, or they're not allowed to have a dog and they have a dog or a cat. Okay. That is a violation of a contractual obligation in a tenant's lease that has nothing to do with timely payment of rent. And it means you can get them into court. You do not have to give them an opportunity to cure. You can simply evict them and get them into court. This is, again, straight guidance from the Department of Justice. Here's another question. What can a landlord do if a tenant has declared that they are a covered person under the CDC order, but the landlord does not believe the tenant actually qualifies? Hello? That's me. And here is the sentence straight out of page 6 of the Department of Justice frequently asked questions guidance on the CDC order. And it says, and I quote, the CDC order does not preclude a landlord from challenging the truthfulness of a tenant's declaration in any state or municipal court. This is what you should say to the clerk who says we're not accepting dispossessories. You can say the protections of the order apply to the tenant until the court decides the issue, as long as the order remains in effect. The order is the CDC order, and it's in effect through September, I think, the 30th. So this clearly says you are not precluded from challenging the truthfulness of a tenant's declaration in any state or municipal court. And I'm telling you, this will allow you to get your warrant and a summons served on the tenant, which will catch their attention. What if individuals act in bad faith when completing and submitting the declaration? It goes on to say that anybody who falsely claims to be a covered person may be subject to criminal penalties, perjury, and other applicable criminal law. Big deal. Guess who's intended to enforce the order? The Department of Justice. So I don't think you're going to see the FBI out there locking up your tenant for falsely claiming to be a covered person, but you have a right to challenge that. So my tenant hasn't paid rent. They get a demand notice, and then they ask me about the order, the CDC order. Mr. Adams, what do you know about this CDC order? Because I don't think I'm going to be able to pay the rent. Don't tell them anything. You have no obligation, again, under the guidance of this Department of Justice frequently asked questions. The landlord has no obligation to give them information or any forms regarding the CDC order. So I wouldn't say anything about it. In fact, I just say, I don't know anything about it. Okay. If they file a declaration, I do recommend you call your attorney for advice. I'm not an attorney and I can't give you legal advice, and I'm not going to. However, your attorney is best able to give you advice relevant to your situation, and no two situations are exactly the same. My guess is that your attorney is probably already attending this webinar and is familiar with this procedure. But if they're not, you need to get them familiar with it. And they can call me. I'll charge them $5,000 an hour to educate them. Number 4, you can go ahead and file a dispo charging untruthfulness and ask for a writ of possession and a judgment for past due rent. And this is going to catch their attention. And it's going to particularly catch their attention because I recommend that you use a process server. Now, some of you may not be familiar with what a process server is, and they're not available in every county in Georgia, but they are in most of the populous counties. And it's because in various parts of the state, various courts employ differing groups of people to serve papers within the county. Some counties use the sheriff. Some counties use the county marshal. Some counties will also allow a court to appoint a process server. It is not unusual for process servers to be former sheriffs and marshals who have retired but want to pick up a few bucks. And why would you, since you've already paid in your fee for the local sheriff or the local marshal to serve this warrant, why would you pay somebody else to do exactly the same thing? Because you want to get what's called personal service. The sheriff and the marshals, I regret having said this. I said they do not care. It's not a matter that they don't care. It's that they are overwhelmed. They have far too many warrants and writs to serve and too little time to do it in, and they're not paid enough, and they do the best they can. Margie, would you remind me to change this? That's not fair to say they don't care, because I think the majority do, but they just can't. There are not enough of them and not enough time. If you use the sheriff or the marshal, there's about a 90% chance you're going to get what's called tack and mail. And under Georgia landlord tenant law, tack and mail will not allow you to get a judgment against the people for the amount of money they owe you, because they can say, well, I never got the summons and it wasn't handed to them. The beauty of using a process server is you can tell that process server, I've got to have personal service. I need you to find this person or a member of their immediate family, hand it to them and get a signature. And I want you to be able to testify in court that you handed it to them. It has to be an adult. It has to be somebody, either the person named anywhere or an adult person living at or residing at the premises. Okay? This is going to catch their attention when you get personal service, or maybe it won't. Yeah, who knows? Some of these people just don't want to pay. Others can't pay, or they think they can't pay, but they're not trying very hard, are they? But what this allows you to do is, once they've been served, you can go and sit down with them and say, hey, the owner of this property is taking you to court, and I'm sorry that you've got this declaration, but that's up to a judge to decide if that's valid. So I think the easiest thing to do would be for you and me to sign a consent decree to take to the judge that says you want to stay, but you promise to get caught up or something like that. If they refuse to do that, or they fail to appear in court, judges hate it when they send out a warrant. They know the warrant has been served on somebody, and that person just ignores the demand of the court. It's not that the judge is offended, it's just that the honor of the court is offended. And you're going to win when that happens. And if they fail to appear when they're supposed to and where they're supposed to, you're going to get, because you'll be there or your attorney will, you'll get a writ of possession and a judgment. And it only costs an extra $150 or so to use a process server. How do you find one? Search whatever county the property is located in. So let's say it is Cobb County. Just put in Cobb County Process Server, and you'll find somebody advertising on the internet that says they have been appointed a process server by this particular county. Okay. So you get this personal service. Then what? Number one, if they don't answer, you win. Well, I already said if they don't answer, and you get personal service, you automatically get a writ of possession and a judgment. Okay. If they answer, you win unless they appear. And there's a pretty good chance that they will answer, but they may not appear. They can't get off work, or they forget about it, or decide it's not important. They just may not be there. You're going to win by default. Number three, if they appear, the judge is going to say, what's this all about? And you can say, Your Honor, I'd like to ask the tenant to prove that they have, quote, used their best efforts to obtain all available government assistance for rent or housing. And I'm here to tell you, boys and girls, that is impossible. There are literally hundreds of sources of available government assistance for rent or housing right now. Everybody from the local church all the way up to the state of Georgia, to Department of Housing and Urban Development. I mean, there are literally hundreds, and they have sworn now that they have used their best efforts to obtain all available government assistance for rent or housing. I think the answer is they have not. And then, instead of asking the judge to rule on this case, because you don't want to trust the judge is liable to be compassionate. The judge is liable to say, oh, they've had such a hard time, I'm so sorry. Say, Your Honor, I really would like to know, would it be possible for us to have some in-court mediation? They love mediation. Mediation gets the judge off the hook, and it does a couple of things. And they have mediators right there to help you in most counties. And once you go into mediation, you need to make it real clear to the mediator and to the tenant that if they want to stay, they have to agree to a consent decree, which will be agreed to by the court. And your attorney can assist you with that consent decree. But the consent decree says we all of us want to avoid an eviction. And so here's what we're going to do. We're going to pay the money back to the landlord over a period of time. We're going to not miss any rent going forward. And we're going to obey all the rules and regulations of the lease going forward. And in the event that the tenant fails to do that, then the landlord will obtain a writ of possession and a judgment instanter, which means instantly. You don't have to file a new dispossessory. You just go back to the court and report that the person has failed to follow this becomes a court order. And the court order is great because once they have failed to follow the court order, you can get a writ immediately and a judgment immediately. They have 7 days, then they have to be out of the property, or you can have their stuff set on the street. Again, your attorney will need to help you with this consent decree. But my advice to you, my friends, is to get them into magistrate's court as soon as possible, and then seek a court order in the form of a consent decree. And by the way, there are 3 people that sign these consent decrees. There's the tenant, there's the landlord or the landlord's representative, and the judge. That's why it becomes a court order. That's why it's called a decree. Okay, the judge has the power to do that, and they'll love to do it because it avoids them having an eviction. So let's look at part 2 here. Is it time to raise the rent? Well, I think these things are self-evident. The economy is just doing great. I have never seen the Federal Reserve put its foot to the floor so hard for so long, and they have no intention of backing off, even though we're going to be seeing inflation soon. Unemployment is falling. A year ago right now, I believe it was at 16%. Currently, it's at 6%. And if you'll look around, there are signs everywhere that says now hiring. Why aren't people going back to work? Because they're making more off unemployment and the federal stipend than they are working. So, I mean, this is all going to change and change soon. Rising sale prices are squeezing renters. And if you haven't considered raising your rent during this time period, I'm just suggesting you consider it. Median rent in Atlanta. Remember, median is not the same as average. Median is that point where half of them are above and half are below. Okay. So a median is a more meaningful term, I believe. A 1-bedroom in Metro Atlanta is renting for $1,429. A 2-bedroom, $1,901. I know. Yours is not that fancy. That's okay. But I do want you to know that over the last year, particularly homes in the fringe of Metro Atlanta, outside 285, rents are up 10% or more. DeKalb and Gwinnett rents have been jumping, and it's in the top 20 counties in terms of the increase in the U.S. So what is your competition? And you can find out about what your rent ought to be by checking Zillow, Craigslist, Rentometer, and My Rent Rates. And when can you raise the rent? In Georgia, you can raise the rent when your lease says that you can raise the rent. Certainly, when the lease is up, you can raise the rent. And during the lease itself, you can raise the rent if the lease says that you can. So read your lease. More importantly, how much can you raise the rent? And in Georgia, we do not have, and I'm predicting we'll never have, rent control. And so that's one of the great benefits of living in Georgia. So my advice is for you to answer this question. Who determines the rental rate? No, it's not the landlord. No, it's not the tenant. It's what the market will bear. So it's incumbent upon you to find out what the market will bear and move your rent to the market rate, or maybe just below it. I love to stay just below the market rate, make my home more attractive. So you need to become proficient in conducting a rent survey. And here are 4 websites that I recommend you jot these down. And these will be very helpful to you in terms of getting an idea of what other people are charging. The granddaddy over here is Zillow, and I like Zillow because they cater to people who aren't willing to use a real estate agent. You know, when you see a real estate agent involved in a rental transaction, there's usually something else going on. A lot of times the agent has been told, well, I want to sell the house a year from now, but I'd like to rent it in between. Will you rent it for me? And the agent doesn't really know much about rentals. Agents aren't usually, traditional real estate agents really have very little experience in rentals. They say they do, but they don't. And there's no money to be made to speak of in rental management. It's all in commissions. And so Zillow tends to attract the do-it-yourself landlord, even the ones that are not with real estate companies, as does Craigslist. And Zillow has a rent estimator. Craigslist does not have a rent estimator, but it does allow you to pretty easily see what people are asking for rent in the area where your property is located. These two are a little bit more sophisticated. Rent-O-Meter, I really like because it gives you actually a map of where your competition is located, and claims to have a huge database of rentals to draw from. All of these are free, by the way, and my rent rates uses a different algorithm. So all of these I think would be helpful. You also can once again go to the courthouse or get on the computer and find out which properties in your neighborhood have the tax bill being sent to a location different from the property. And when you see that, that indicates that this is a non-owner occupant situation. And you can just knock on the door and say, hey, I'm conducting a rent survey. Do you guys rent? We pay $5 for every house we get to interview. And they'll say, sure, yeah, we rent. And say, okay, how much is the rent? And what do you like most? What do you like least about the neighborhood? And how many bedrooms and baths have you got? And they'll tell you all that stuff. And after you've hit about 10 of them, you've got a pretty good idea of what's going on. So all of those will work for you. So let's say you do decide you want to raise the rent. Well, I have developed, and this will be made available to you today. And by the way, all of this you can get by going to realestatecoffeebreak.com, 4 words, realestatecoffeebreak.com, and clicking on resources. And there you'll find the Department of Justice guidance. You'll find the mandatory declaration, so you'll know what it looks like. And you will find a copy of my nice rent increase letter for a recovery after a pandemic. And I've never written a nice letter before, so this was a challenge for me, but I think you'll like it. And notice I've said right here, it's sent by both mail and email. I don't add the word for documentation, but I am able to document that I sent this to them. Because one, it's permanent in the email, and I took a picture of the envelope with a stamp on it. Okay. Steve and Jennifer Smith in Smyrna. Hi, or dear Steve and Jennifer. I want to take a moment to let you know how much I value both of you as residents. It's not easy to find residents that consistently pay their rent on time and also take care of the property so well. Frankly, I don't care if they do pay their rent on time, and I don't care if they take care of the property. It's just sort of a nice thing to say. Unfortunately, I was notified today by my district manager that the owners have experienced a substantial increase in costs associated with this property that are prompting the need for a rental increase. In addition to other rising costs, there have been substantial increases in property taxes and insurance premiums that were unavoidable. I want your tenant to understand that you have costs associated with this property. You don't, I've had landlords say to me, well, I own it free and clear, so I don't care if I go up or not. No, you may own it free and clear, but you still have to pay property taxes. You still have to have insurance on the property, and these things are getting more expensive. Likewise, you may need to drive to the property. Anybody been to the gas pump lately? It's up $1 since January 20th. So maybe we did need the Keystone Pipeline. I don't know. And then I say your current lease automatically terminates May 31st at 11:59 Eastern Time. We would like for you to continue as residents, but an increase of $124.50 will be applied to the new lease term beginning June 1st, 2021 and terminating on May 31st, 2022. If Steve or Jennifer called up and asked if I could meet them in the middle, I would say, I'll ask, but I'm not optimistic. And then I would come back and say, the least that they could live with was $99.50. Or whatever. If you want to meet them in the middle, that's fine, but get it up some. The current rent, the rent is currently $11.95 a month, and under the new lease agreement, we'll need to increase to $1319.50. I regret that this property is not available on a month-to-month basis, nor may we extend the lease for a period of less than 1 year. Remember that you should always control when the leases expire, and they should always expire in the spring or early summer, because that's the maximum moving time. You don't want a lease to expire on December 25th because nobody's moving between Christmas and New Year's, and you're going to have a vacancy. Okay. Again, I thank you for taking care of the property and being model residents that you are. I hope that you will continue to remain residents at 1234 Oak Street. If, however, you have decided to vacate by May 31st, please notify me by email at least 30 days in advance as required by your current lease agreement. And if you have any questions, don't call me, email me, because I want a permanent record of it. Best regards, blah, blah, blah. Okay? So if they are going to stay, and I hope they are, if they're good tenants, if they're not, get rid of them. But if they're good tenants, I don't mind you negotiating with them. But now is a good time to introduce e-signatures. Now is a good time to have a new inspection. Now's a good time to introduce a new lease. Now is a good time to introduce them to electronic rent payment, and we prefer Zelle. And my friend Ian Robbins and I have been talking about Zelle on Real Estate Coffee Break every Saturday. Would like to invite you. And there are a lot of different ways now that your tenants can pay. But the beauty of Zelle is it doesn't cost you a penny. They can't charge it back. And it is almost instantaneous. And that's why I like it. Once I got the money, I don't have to worry. It's in my bank account and it's good. We don't have to wait for it to clear. This is also a good time to introduce strict enforcement of the lease and blame it on the owner. Alternative, if you don't want, this is a great time to sell when the property is cleaned up. So if you're thinking about doing that, do it now before interest rates go up. You're going to get top dollar either way. And that leads me to part 4, and I've got just a few minutes left here. And I see 7 or 8 minutes, so I think I can do this. Part 4 is what's new. And why do we change the lease so often? I've had complaints from people say, John, I bought your lease back in 1994 and I'm still using it and it's great. Why do I need the 2021 version? That's going to cost me a whole lot of money and I'm cheap. Well, guess what? There's a lot of new stuff going on. And we have had huge changes over the years, and it's become much more real estate in general, and leasing in particular has become much more complex, especially from a lease and document standpoint, because the lease controls and documents your agreement with the renter. So let's talk about real quickly what the changes are we monitor constantly. First is changes in federal law. Good example, Americans with Disabilities Act. And I'm not going to comment on whether it's good or bad. That's for you to decide. But it is the law of the land. And this law was, the laws were altered to ensure equal opportunity in housing for people with disabilities. And I think it's interesting. The ADA does not name all of the impairments that are covered. So every now and then some court somewhere decides that a particular impairment is or is not covered, and most likely is covered. And we're going to need to include that information in our document. But this goes on all the time, changes in federal law. Then we have changes in the Code of Federal Regulations. Now, you may have seen this as CFR, but get this. This is a requirement that's proposed by a federal agency. It is never voted on in Congress, but it carries the force of federal law. A good example is the EPA's lead renovation, repair, and painting rule, or the RRP rule. And it requires firms performing renovation, repair, and painting projects that disturb lead-based paint in homes built before 1978 to be certified by EPA, to use certified renovators who are trained by EPA-approved training providers and follow lead-safe work practices. Congress never voted on this. It just happened. It's in CFR. So I'm just telling you, this happens all the time. And lead-based paint's an example. Changes in state law. A good example of this is in Georgia. In 2015, the Georgia legislature passed an act called the Notification to Prospective Tenant of Property's Propensity Toward Flooding. Now, this law does not apply to Alabama or to Tennessee or South Carolina or North Carolina or Florida, just to Georgia. And it's called OCGA 44720. And the law applies, it says that if a property has flooded more than once in the last 5 years, then you have to disclose in writing a flooding disclosure statement. So every state in the union has different sets of requirements, and I can't keep up with all 50 plus Puerto Rico, but who knows about the Virgin Islands? But anyway, that's just an example of a change in state law. Changes in federal judicial branch interpretations. This is a very interesting example, and these are just examples. The United States Supreme Court in 2015 held that housing discrimination could be shown not only in cases where the landlord clearly intended to treat one group unjustly, but also by showing that the landlord's policy, although neutral on its face, had the effect of harming people in a protected class. So this was 2015, 135 Supreme Court 2507. In other words, a landlord can no longer refuse to rent to a person with a criminal record because the Supreme Court found that allowing such flexibility had a disparate impact on certain protected classes. So you can't say, this guy has 15 DUIs in the last 15 years. The guy's a drunk. I don't want him as a tenant. because the Supreme Court does not believe that a DUI has anything to do with whether or not they'll pay the rent on time. I respectfully disagree. I wonder what would happen if that were interpreted by the Supreme Court today. But we've got to know these things. This is the disparate impact, which to me is sort of a stretch, but hey, I'm not on the Supreme Court. Changes in state Supreme Court interpretations. Every state in the union. Why is there not a Y there? Every state in the union has some form of judicial Supreme Court. And while they must adhere to federal law, they're allowed to interpret their own laws and rules and regulations. A good example was last year when the state Supreme Court declared a state of judicial emergency, allowing each individual court in Georgia to adopt extraordinary measures to protect the courts during COVID-19. And the state of the judiciary has independent authority to do this pursuant to Code Section 38360. And on April 3rd, 2020, the Georgia Supreme Court did just that. And that's important for you and me to know that. And so we reacted to that. Changes in the decisions of local superior courts or the various judicial circuits. This is great. While the decision of a superior court judge is always subject to appeal, these decisions are often quoted as providing precedent in various landlord-tenant arenas. For example, there's no law in Georgia, none, limiting late fees that a landlord can charge a tenant. However, several Georgia Superior Court judges have simply made up their minds that the late fee must be reasonable, and they've decided that reasonable means 10% or less. Now, that's not stated anywhere. That's not in the court handbook. That's not in any official code of Georgia annotated. It's nowhere. But a lot of Superior Court judges, and now unfortunately some magistrate court judges, have been told that's what we do. And that's just an example of what I call made up law. Changes in county ordinances. Get this. On February 26, 2008, the idiots of the DeKalb County Commission approved the inefficient plumbing fixtures replacement plan. So any home built prior to 93 must have low flow toilets and plumbing fixtures installed before a renter or an owner can get the water turned on. Now, the tenant's not going to be willing to pay a licensed plumber to install and certify those low flow devices, because this can cost $1,000. So it falls to the landlord. Now, in my personal opinion, I think this ordinance is unconstitutional under the Equal Protection Clause of the 14th Amendment of the United States Constitution, but nobody has told the DeKalb County Commission that. So if you own rental property in DeKalb and the tenant moves out and a new tenant moves in, somebody's going to have to certify that there are, you know what a low flow toilet is, don't you? It's one you have to flush 3 times to get it to clear out. It actually uses more water than a regular toilet, but don't tell them I said so. Number 8, every little city wants to get in on the act. A good example is the stupid city of Marietta, which in 2004 enacted a rental housing inspection ordinance requiring landlords to obtain rental licenses for all rental properties. And to obtain a license, the landlord had to hire and pay a city-approved rental housing inspector, Fonus T. Balonis, to inspect and certify that properties were in compliance with all housing codes. There's never been any property that's in compliance with all housing codes. A local landlord group promptly sued. They lost in Cobb County Superior Court, but they appealed and they won in the Georgia Court of Appeals. Interestingly, city of Marietta appealed that decision of the Georgia Court of Appeals to the Georgia Supreme Court, who declined to hear the case. So the city of Marietta was slapped down, and folks that own rental property there are treated like everybody else. That's called equal protection, I think. Number 9, the General Assembly. Now listen to this. This just happened recently. And I don't want you to be mad at me, because I am compassionate. As an Eagle Scout, I'm not required to be compassionate, but I am. And I understand that family violence is a terrible thing. And I'm not in any way condoning it or encouraging it or anything else. And I'm all for helping people that have had to suffer family violence. But on the final day of this year's session, which means they didn't want to do this in the light of day, both houses, the Senate and the Georgia House, passed the Family Violence Lease Termination Act. It's called House Bill 834. And when a civil or criminal family violence protective order has been issued, a renter can end her lease by giving the landlord a written notice of termination. Now, the notice should include the fact she is ending or terminating the lease based on the fact that the renter or her minor child is a victim of family violence, and should include the new end date for the lease. The end date has to be at least 30 days away. Now, real quickly, I get it. And I want to immediately say that I am not unsympathetic to victims of family violence. Quite the contrary is the case. I'm going to stop sharing just so you get this straight, because I don't want any of you people to say later, John wasn't clear on this. I am very sympathetic to victims of family violence. I just want to know why the landlord should be left holding the bag. It's sort of like a game of musical chairs, and the landlord is the last one standing up when the music stops. So let's go ahead and share again. And here's my proposal. You ready? If the Georgia legislature wanted to address such a difficult situation, why not appropriate several $100 million to pay landlord for the unexpired portions of the lease that are created by this legislation? Why should a landlord be left holding the bag? I fully support the victims, okay? But it's the idea that a landlord somehow, well, you can just eat it up and rent it to somebody else. What if the house is all beat up? I'm just telling you, these things happen. So we've got to watch the Georgia legislature constantly, because they're liable to come up with some foolishness like this at just about any time. And then number 10, I'm almost done. There are changes from time to time in fears of the general public. Most recently, you've seen the public has been inundated with warnings against toxic mold and mildew. There is no such thing as toxic mold and mildew. In fact, there's mold and mildew everywhere and has been for hundreds of millions of years. But many unscrupulous renters have used the supposed presence of toxic mold as an excuse to break their lease and not meet their financial obligations. Before that, it was asbestos. And right now, the new hot topic is radon. Oh no, there's radon. Guess what? You know how to mitigate radon? Put a fan in the window. I'm not kidding. Because often these actors are nothing more than scams designed to line the pockets of so-called experts. We had to modify the killer lease to protect landlords against all manner of unpleasantness. And what we had to do was literally shift the responsibility for preventing mold and mildew onto the shoulders of the tenant, so they couldn't use it as a financial club against the landlord. And finally, ready? Changes to the rules and regulations of the Georgia Real Estate Commission for licensees. Why do I have to watch this? One, because I'm a broker. And two, because many of you guys are brokers as well. You know, it's not unusual for a person who owns a few rental houses to also have a real estate license. And the commission comes up with these rules that only apply to brokers and licensees. But for example, if you're a licensee, there's a new rule that states your broker's name must appear in any ad at least as prominently as any other printing on the ad, and that the broker's direct phone number must be included. So we are constantly monitoring these 11 areas to try to keep you ahead of all of these changes. And I constantly am designing the Landlord Survival Guide and the new killer lease to protect you and your property. And I'm going to take just a minute now to introduce the 2021 killer lease because I believe that you can retire comfortably on as few as 10 little rental houses. Isn't that a cute little house? That is a perfect little rental house. Not big, but it rents so well. That's an old Craftsman bungalow right there. Look at that. So here it is, the 2021 Landlord Survival Guide. We have just made new updates dealing with COVID and the recovery of the pandemic. It is available, if you're not familiar with it, right now for $197. It includes the completely new and improved killer lease that changes typically about once a month. And my question is, if all this book did was allow you to avoid just one vacancy or one turnover, how much would that be worth to you? And I think you'll remember that the average rent in Metro Atlanta for a 2-bedroom apartment is right around $2,000. So $197 is a small price to pay to avoid a vacancy, isn't it? Or if all this book did was keep you out of federal prison for alleged housing discrimination, how much would that be worth to you? Well, I don't know. What is 6 months of your life worth? Yeah, there are people out there who would like to charge you with housing discrimination, and it's pretty easy to commit, even though you aren't attempting to discriminate. I'm just telling you, how much would that be worth? I don't know. I believe in what Nelson Mandela said, and I'm learning, the more I learn about Nelson Mandela, the more I like him. He said, I never lose. I either win or learn. I want to invite you to join me and never lose. I want to invite you to join me and learn and then win, because the killer lease is the culmination of 40 years of either winning or learning. And I just think this is the way we need to move forward, especially in real estate. I've got a very special offer.
It says a federal judge has overturned the CDC eviction.
Wow, did that happen today?
I think so.
All right. We just have breaking news here on the Excellence in Money Radio Network. We have just been told that a federal judge has overturned the CDC order. We have not been able to independently verify that. What? They have vacated the temporary. How about that? It's on Axios, is what I have been told. So, hey, we won one. Yay. See, all I got to do is just tell you about it. And the power of these webinars causes federal judges to do the right thing. So here's your special offer. Everyone who orders any 1-year subscription to the Landlord Survival Guide in the next 60 minutes, and it is now, let's just say 2:15, so you have until 3, will automatically get a free 25-minute consultation with me on any real estate topic. Now, that would normally be $297. If you want 25 minutes, and I'd love to talk with you about what your goals are, look at your portfolio, make some recommendations, answer any questions you might have. But you must order within the next 60 minutes. And I'm here to tell you, that's great news if that's true. We'll see. Supposed to be true. Well, here are your options. I ought to start doing these webinars more often. We get some great things overturned. Option number 1, if you are a current existing Landlord Survival Guide subscriber, you can add 1 year to your existing subscription. No matter when it expires, it will just be on for another year after that for $99. That is the lowest we have ever offered a 1-year extension. And by the way, if you're confused, you're saying, is this a book or is it a subscription? It is like a magazine subscription. You will subscribe for 1 year, and during that year, every time there's a change in the lease, every time there's a change in a form, every time there's any kind of change, you will have the option of going to get that for free because you are a subscriber. Okay, that's option number 1. Option number 2, if you are a past Landlord Survival Guide subscriber or book owner, you may renew your subscription today for 1 year for only $129. Buddy, this is for the guy who's been using the 1994 lease for the last 25 years. And for only $129, he can come into the 21st century. I mean, this is great. So you know who you are. And option number 3, if you have never been a subscriber, you can purchase a 1-year subscription today for only $197 and still get the consulting bonus with me. That is a heck of a deal because it's normally $497. All right, so here's how you do this. Whatever option you want, go to money99.com, click on webinar offers, select option 1, 2, or 3, and fill out the information that we need. That's all there is to it. You now have 3 choices as I see it, and here's what they are. First, you can do nothing and just continue. A lot of you I know are using the GAR lease. The GAR lease was written to protect the people that paid for it to be written. That's the Georgia Association of Realtors. It's not you, the owner. It's not you, the property manager, and it's not your property. So you can do nothing and just continue using whatever lease you're using now. More power to you. Or you can do it yourself. You know, there's nothing magic in the Landlord Survival Guide, even though it's taken me 40 years to come up with what we have to offer you today. All of this information is public information. I'm not a genius. I just came up with a lot of people shared ideas with me that we've collected and tried and employed over the years. So you can certainly do it yourself. Or, and this is what I would recommend, you can leverage my 40 years of experience and use the resources that are guaranteed to be right for you. You've got to make that choice. And my question to you is, are you in? So here's my guarantee, and I've stood by it for years. We get back about 1 in 1,000 books, okay? If for any reason this package is not right for you, I'll buy it back and we'll still be friends. Is that fair? I think that's very fair. So you've got 30 days to look it over and see if it's right for you. And if it's not, for any reason, I will buy it back and you and I will still be friends. And I just don't see how anybody can offer a better guarantee than that. I want your satisfaction. It doesn't do me any good for you to buy the book or buy the lease and put it on the shelf. I want you to use it and benefit by it. So I want to give you a quick warning. This offer expires in 60 minutes. And the question I have for you is, are you in? And at this moment, that will be the end of our presentation. I'm going to see if there are any questions out here that anybody wants me to address. You can put those in Q&A, please, if you have any questions. And so Howard says, just this minute, I received a news alert from Washington Post that a federal judge has vacated the CDC eviction moratorium. Howard, that is fantastic. I'm going to be jumping on the news channels as soon as we get done here. David, I purchased. Is it ready yet? All of the material, David, is on the website right now. And we are putting a print version together. I think you're asking about the print version, and the answer is no, but it's all there. Everything you paid for, you can get in PDF format and print to your heart's content. So when we get a print version, I'll make sure that you know about it. But for right now, it is in electronic. The reason that we are reluctant to go to print is that it is obsolete the minute it's printed. What if I had printed up 1,000 copies this morning that told you all about how to beat the CDC ban, and then Howard calls and says, what? The federal judge just overturned it. Okay. So then all of those 1,000 are obsolete. So I live in Fulton County. Is it better not to get into rentals in this county? Mike, there's nothing wrong with rentals in Fulton County. It's just that the judges tend to be more pro-tenant than pro-landlord. Consequently, a single landlord appearing by yourself in magistrate's court is likely to be intimidated by the judge. My advice to you would be to go to one of the large landlord tenant law firms that handle hundreds of these things every month for some of the big apartment complexes, and ask them at least the first time to represent you, because they have leverage with these judges. They basically are giving them a job. And the law is the same in Fulton County as it is in Glenn County, or as it is in Cobb, or as it is in Spalding County, or Bibb, or Clark County. But the political environment in Fulton County is anti-landlord. And I just would bring that to your attention. And you should not expect as warm a reception by the judges in magistrate or state court of Fulton County. Now, you can always end up in front of some ultra-liberal judge in DeKalb County or even in Glenn County. They're out there, but the likelihood is less. And I just know what I hear from my friends who are landlords of property in Fulton County. But no, if you come across a good enough deal, you go for it, Mike. David, thanks. Print was what I asked about. I understand. No problem, David. Dwayne, will there be a digital version of the lease that is editable? There's one right now. You always. The lease and all of the documents are available first in PDF if you just want to print it out. Okay. Second, they're available in rich text format, RTF, which you can then bring into Microsoft Word. You can bring that into Google Docs. You can bring that into what does Apple Writer or whatever, the Apple word process, any word processor that you have, Microsoft Word, any of those. And if you have any difficulties bringing these documents into your word processor, we will help you. Now, we are not tech support, but we know how to do it in Google Docs. We do everything in Google Docs, which is very, very similar to Microsoft Word, which I think is pretty much the standard these days. But whatever you prefer to do it in, we'll try to help you get it there. Okay? Okay. By the way, we do not know anything about Linux. So if you're a Linux person, I hope you know how to take it from rich text format into Linux and do something with it, but I'm just not familiar with that. Is your updated lease in there? Of course it is. As of today, it is in there. It's been there for years. Come on, Joan. Mike, thanks for your great answer, John. Okay, well, that's all we've got right now. You guys have been great, and you've got just about 35 minutes left to go ahead and place your order. Once again, I do want to remind you that purchasing the Landlord Survival Guide is unconditionally guaranteed to be right for you. And I'm just going to real quickly mention these options again. If you're a current subscriber, you can add a year for $99. You'll never see it cheaper than that. If you're a past subscriber, you can rejoin the club for a full year for only $129. What a hell of a deal. And this is the best. If you have never been a subscriber, you can buy a 1-year subscription now for $197 and still get the 25-minute consultation that is worth $297. So you just go to money99.com, you click on webinar offers, and you select option 1, 2, or 3. And you fill out the information that we need, and we'll send you right back a confirmation. We'll get you set up today, I think, certainly within 24 hours. So that's the story. You've got 3 choices, folks. You can do nothing, which is what, a lot of people decide to do. That's fine. Or you can do it all yourself. I did it. I stand on the shoulders of John Schaub and Robert Allen, and there were so many people I've learned from. I can't even name them all, but I've learned from a lot of different people over the years. But my point to you is, for $197, why not leverage my 40 years of experience and the experience of countless other landlords and use the resource that is guaranteed to be right for you? So you've got a decision to make right now. It's unconditionally 100% satisfaction guaranteed. Even if you return it, you and I will still be friends. And I want to warn you, this offer expires in 60 minutes. So I just need to know if you are in. Thanks, folks. I really appreciated it. I'll see you guys a little bit later. And I'm going to go find out now about this federal judge. I love it. We're going to win this thing.